Thank you. Please be seated. We are here this afternoon for the submission of 3 cases. The case of P.M. Latner versus Michael Reif is hereby submitted without oral argument. And we will begin this afternoon's cases with Bankers Trust versus City of Des Moines. And it looks like the attorneys are ready. Mr. Bryan, you may begin.
May it please the court, counsel. Good afternoon. I figure I'll start by just providing a little bit of context of how we got here today. So approximately 3 years ago, this case hit my desk when it was alleged by Sally Splitgerber that she fell outside the premises on the sidewalk of my clients and broke her wrists. She asserted a claim for negligence against my clients. They were responsible as property owners for the condition of the sidewalk. So it had been a few years since I had had a sidewalk case, so I started by looking at the statutory authority and the case law authority to figure out, okay, well, what is the situation here in regards to who's responsible for the maintenance of the sidewalk in question? How does the city as a sidewalk owner factor into all this? So I began then by finding the Madden case from 2014 and reviewing that along with the state statute in question that's discussed in Madden. Then I read the Fulps case from 2021, I believe, sort of caught up to speed on what the case law was, but couldn't get around, as I read it, the question of how the Madden court got to the point of determining that there was full indemnification owed to the city when analyzing the city ordinance in question in that case, which was identical to the city of Des Moines in my case here. I couldn't get to that point, and so I highlight to the court the section in Madden in the analysis at, I don't have the exact page here, it's in the analysis section where it says, here there is no such conflict between the statute which relates to the maintenance of sidewalks and the city's ordinance, which expressly states that abutting landowners are liable for damages resulting from the sidewalk defects. And it's the R word in that analysis and the court's conclusion there that kept tripping me up in the analysis. Ultimately, because I would look back at the city's ordinance, the Des Moines ordinance, where it says the abutting property owner may be liable. And so ultimately that's, I believe,
Madden is really kind of the interpretation of the ordinance in that case where it says may be liable versus I think the court interpreted it as shall be liable. Is that kind of the real heart of the issue for you on Madden?
For me, yes. That's what tripped me up in trying to give my client advice on how this would play out in defending themselves in the case and how the city played into that.
So let's assume you're right on that part of it, in that if we look afresh at this ordinance, it says may be liable, but not necessarily liable. How would that play out? You've asked for a trial on comparative fault. What would that look like?
So I believe that the trial then would be both parties at that point, the city and the abutting property owner, would have comparative fault weighed by a jury to determine if they were negligent, at fault at all, and then weigh their fault against each other.
Disentangle. I'm sorry, keep going, because I think we're going.
On these facts, like what would that trial look like? What would be the alleged kind of negligence on the part of the city versus the alleged negligence on the part of BT?
Well, that didn't really come up in this case. If we had that, there would be a factual record that's developed more on those issues. I mean, I cite to the deposition of the city's sidewalk maintenance supervisor, Mr. Silvers, and some of the things that were raised in that deposition that I said to the district court, at a minimum, that creates a fact question for a jury to decide if we were to have comparative fault analysis. But really what got us here to this case is that even possible to go down that route? And so I understand your question saying, if we were to go that route, how does it play out? But I think my first thought was, is it possible? I don't see how it's not with the city. I don't see how the city ordinance can convey full indemnification against my client based on may be liable. It just inherently creates that question.
I mean, how do you have a jury apportion fault without some preconceived notion of who has the responsibility, which gets us back to Madden?
Right, and I incorporate the dissent in Madden as my argument as well, to Justice McDonald's point. That's what tripped me up in the analysis, was the full indemnification. You are liable automatically, or you are responsible for the full damages regardless of comparative fault. But I think the Madden dissent raises the points about the actual 364.12 statute and how it interacts with the City of Des Moines ordinance as well.
What is it about that statute that you think preempts the home rule rights that the city would have here?
I have nothing more intelligent to say than what that dissent says itself. I could repeat it, but I would humbly say I'm not going to enlighten that argument any more than how it was written. Ultimately, if you look at
Say you can't do better than my dissent, but we have an issue where, Madden's been the law now for nearly a decade, as I recall, and the legislature hasn't done anything with it. And you say it's unworkable in your brief, but I'm not sure that it is unworkable. It's a clear rule. It makes the abutting property owner legally liable. I mean, that's their responsibility, and I presume they can insure for it, and often do. So why is that rule unworkable?
I understand that premise of what you just said, Justice Mansfield. What makes it unworkable is what brings me back to Justice McDonald's original question, which is how, when we look at the City of Des Moines ordinance and that subpart D that says may be liable, where do we get to a situation? Because the city admits in their briefing that there could be a situation where the city would have comparative fault, but this says this case isn't the one that is ripe for that sort of analysis.
Because we don't know how to instruct the jury to divide fault. Is that the problem, or?
It's unworkable because I can't explain to my client unless I'm just, unless it's a me problem. I can't explain why there's full indemnification when the statute says may be liable. That to me sets up a situation where they could be liable. And that's a discussion as to what you're bringing up, Justice Mansfield, is, okay, if we say that the city ordinance is allowed and not preempted by the state law, then we look to the city ordinance, because in Fulps, I believe the court references that the Urbandale ordinance in Fulps had a direct right of indemnification in that Urbandale ordinance. The City of Des Moines ordinance does not have a direct right of indemnification in it. So when we look at Madden and we give guidance through the court to future litigants, how do they look at that and say, when you look at each individual city ordinance, is there an automatic right of indemnification or not? If the right of indemnification is allowed, the City of Des Moines could have done that. They didn't. So for this,
What in the statute would preclude the city from doing that? And let me preface the question with this. I mean, we do have a rule of stare decisis, and on cases of statutory interpretation, our case law says that we won't overrule a decision unless it's demonstrably erroneous, clearly erroneous, palpably erroneous, et cetera, which seems to me to indicate that we owe some sort of deference to prior decisions unless you can point us to something that says this is very clearly wrong and prohibited. So what in the text meets that threshold of wrongness?
the Madden decision.
Statute that would preempt or disallow the city from exercising this power.
Okay, to your direct question, of 364.12, sub B was amended after Peffers by the legislature, but sub C was not amended, which then harkens back to the argument that if B was amended to create a direct cause of action and sub C does not have any cause of action directly against the abutting property owner, and D then, sub D to 364.12 says that the city can pass along by state statute the maintenance costs, but there's still no direct cause of action for liability, then it makes it superfluous, I believe is the answer to your question specifically. I thought you were asking me then about what about Madden says that stare decisis shouldn't apply.
Cases, right? We say that we won't find conflict, field, or implied preemption unless the statute and the ordinance are wholly irreconcilable. They just can't exist with each other. And I don't see anything in 364 that makes the city's ordinance just totally ineffective or totally precludes it. So that's what I'm looking for from you is what statutory text is wholly irreconcilable with what the city of Des Moines has done here?
Anything to provide you on that answer that's not in the dissent into Madden. I do bring up the fact, though, that if you talk about stare decisis with Madden and the principles of that, which I don't take umbrage with, but I say that the reason it's unworkable and should be overruled or overturned, at least at a minimum, to address and clear up this clarification with the passive versus mandatory type language, which comes back to how we started the discussion today.
I'm indirectly flattered because I joined the dissent, but you know, we do value stare decisis, and anytime we overrule a case, we, to some extent, undermine the predictability and stability of the law that, you know, you rely on to advise your clients. What is the law? So why should we, if Madden was a mistake, why should we fix it when doing so would undermine stare decisis?
Without sending the horse to the glue factory, I believe that Madden, as I read it, and the confusion that it created for me, will creates confusion for others in dealing with these individual municipal ordinances and their application to 364.12, because I cannot answer the question. And again, when I read your decision, enlighten me, but I cannot wrap my head around that passive versus mandatory language and how that does not create. Why does it create a situation where the abutting property owner automatically is entitled, or automatically is responsible, for the full freight in that situation? That's where I come back to, however you folks in your infinite wisdom decide to address this, it comes back to when I read through Madden, I'm like, okay, I follow, and then I feel like it just jumps to full indemnification without an explanation. And I thought at one point it was like an agency argument that it was trying to make in talking about joint agent, but that didn't really make sense to me. So that's where I come back to it's unworkable, because how do you apply it? How do you apply that precedence and give guidance when there's no analysis or explanation as to, and the beauty of it is, for this situation, is the Iowa City ordinance is exactly the same as the Des Moines ordinance, but I bring up what I said to Justice Mansfield a minute ago. If you look at the Fulps decision and the Urbandale ordinance, if you're allowed as a municipality to pass along indemnification, then just do it.
Government reliance play in our stare decisis analysis. So, you know, if you're a city administrator or manager and you're looking at the case law and you look at Madden, you structure your government operations in terms of inspections and maintenance of sidewalks based in part on that law, knowing that you can pass liability or get indemnification from property owners. It seems to me that's a fairly significant interest, but you have municipalities all over the state kind of structuring their operations based on that law. What role should that play in our consideration? And certainly the legislature could fix it. I mean, the cities, the League of Cities, ICAP, I mean, all of these organizations, they have lobbyists and, you know, they know how to pass legislation. So what role should that play?
I think it plays an important role, and without doing the dreaded answer a question with a question, I'll run the risk of saying, why doesn't the city of Des Moines just put the right of indemnification into their statute if it's allowed. I think their management in each individual city's management of how they're going to handle their sidewalks, whether they're a small town with a mile of sidewalks or a large city like City of Des Moines, the factors and variables will be different for each of those municipalities. But if they can do it, why don't they? And in this case, speaking of the facts of just this one, they didn't. That's what I come back to. I see that my time is up. I'm sorry.
Quick, so what resolution are you looking for then? If Des Moines had put shall instead of may, would you be here asking us to overrule Madden?
Yes, because I believe the dissent from 2014 is correct. But I believe that this case brought up the opportunity to show the problems that could come from the Madden decision and the issue with the indemnification. So on this case specifically, yes, I would still have made the application on behalf of my client. However, this case shows twofold why we're here.
To, even if we don't overrule Madden, then address the may versus shall?
I'm asking first and foremost to find that the dissent in 2014 was correct. Alternatively, I'm asking for a remand for a comparative fault analysis because of the may versus shall, and that ultimately it's a trial court issue to determine whether or not they're liable, because it says they may be liable. So the trial court would be the place to decide if they are liable. Thank you.
I was looking at the next one, sorry.
May it please the court, counsel. The City of Des Moines asks that this court affirm the district court finding that Bankers Trust is responsible for the damages in this case. The City of Des Moines ordinance imposes on adjacent property owners an obligation to maintain sidewalks and imposes an indemnity obligation to the city when that obligation to maintain the sidewalk is not met. A couple of arguments that came up during Mr. Bryan's argument I want to address. One is the remand for comparative fault. I think that that issue has been waived because the district court didn't address it. In ruling on the cross motions for summary judgment in this case, the district court started its analysis with the only dispute is whether Iowa Code 364.12 and the Des Moines Municipal Code Section 102-2 make adjacent property owners responsible for maintenance of the city's sidewalk. It analyzed that issue. It came to the conclusion that Madden was controlling and ended its analysis. It had no further analysis of, even if I follow Madden, we have to look at this comparative fault issue. Because the district court didn't address that issue, there was no motion to enlarge the ruling. I think that issue has been waived. I also question whether that issue was raised in the initial briefing in this case. I know it was in the reply brief, but I don't think that the reply, bringing it up for the first time in the reply brief is sufficient.
Argument that I think maybe could have been made about whether liability could be imposed here based upon the special sidewalk, that it was constructed differently to kind of fit in with the landscaping. Was that argument raised below?
A footnote in my brief for a reason, because I agree that hasn't been preserved. One of the other arguments that was discussed was the may versus shall language. And what I would say from that is that, you know, both Iowa City and the City of Des Moines have the may language in their ordinances saying that if the property owner does not meet its maintenance obligation, they may be liable for damages. And I think that where we got, I wasn't there when the ordinances were passed, I think that where we got that language was the Iowa Code. 364.12 subsection 2B deals with the removal of snow and ice. It's what was at issue in the Peffers case. In Peffers, it was found that the statute didn't specifically impose liability, though it did have the maintenance obligation. The Iowa legislature amended that, and the language it put in was, if adjacent property owners don't maintain the sidewalk, they may be liable. This court then found in Fritz v. Parkinson, still in the 1980s, that that may be liable language was sufficient to impose liability.
As soon as you bring in Peffers, then now you're in the position of having to defend the majority opinion of Madden, right? City owns the sidewalk, right? We don't dispute that. 364.12 starts with the general rule that the city is responsible, correct? And then we have these exceptions, B, C, and D. The only exception that talks about damages is the snow removal one in B, correct?
Absolutely talks about damages, yes.
About damages in C and D. So, I mean, isn't it logical then that that you can't get damages for under C or D, or you can't create an ordinance? You're then, if the city wants to impose damages, the only basis for doing so is B. Otherwise, the city is bound by the general rule of that it's responsible.
For a couple of reasons. One, I think that you could read subsection D as addressing damages, because what subsection D says, as I'm sure you know, is that if the city finds a defective sidewalk, it can tell the adjacent property owner, hey, you need to fix this. If you don't, we're going to repair it and bill you for the cost. That's a little bit different, but it's a way for the city to recover damages. But subsection C tells us that cities have the authority to impose the maintenance obligation, and it does not have any language to say the city can't also impose an indemnity liability obligation, which the city would have the authority to do under its home rule powers. And Iowa Code Section 364.2, subsection 2, specifically tells us that even when the legislature tells a city you can do this thing, it doesn't automatically mean that a city can't do another thing, because
Automatically, except that you start with a general rule that the city's responsible in the language under 2, correct?
Subsection C, in granting cities the ability to make adjacent property owners liable, it carries with it the ability to impose that indemnity obligation. I think that another place we can look at in the Iowa Code to indicate that the legislature intended the city to be able to have that indemnity liability ability is Iowa Code Section 364.14. That section says that if the city is sued for a negligence action and it believes that the negligence of a third party is the cause for the damages, then the city can put that party on notice and bring an indemnity action. And so what the city, both here and in Iowa City, are doing is already consistent with Iowa Code Section 364.14 and is authorized by 364.12, subsection 2C.
A legislative acquiescence argument in your brief. What year was this statute passed?
The Iowa Code Section 364?
Right. So typically, we interpret statutes to try to give it the meaning that it had when it was passed. And I get that it was passed at different times. I think it was first passed in 1972, and it was amended a few times after that, amended in 1984. What year are we generally looking at to try to give intent to the words of this statute?
I think that we would be looking at the intent from the time that it was passed, but the Iowa Supreme Court looked at the language of the statute and the intent in 2014, said that it was consistent with Iowa City's ordinance, and we haven't had a change from the legislature since 2014. So we have almost 10 years now of legislative acquiescence where we can say this is what we understood the statute to mean, and the legislature hasn't told us that we were wrong about that.
Well, what should we infer from that?
That the legislature agreed that cities should have the authority to both make adjacent property owners responsible for maintenance of sidewalks, and that they don't have a concern about the cities also imposing the indemnity liability obligation, which we see both from legislative acquiescence and from the fact that there's an entire another code section that would give cities the ability to impose to bring those types of indemnity claims, even if there wasn't a city ordinance to do that.
The issue I'm struggling with is, let's assume you're right, the city has home rule powers. It could impose indemnity obligations on abutting or adjoining landowners. But the may language strikes me as not achieving that purpose. I mean, it'd be one thing if the ordinance said shall, but if may doesn't, I mean, are you saying may means shall in this context? Or, I mean, doesn't may mean may, and it depends on the facts and circumstances of the case, and we should have a jury trial about it?
I think that that could be true in another case. I've had cases like that where, you know, the city took the position, well, there was an injury that resulted from a sidewalk defect, and so the adjacent property owner is responsible. And the adjacent property owner said, well, no, yes, that's true, but also we're looking at this, and this action taken by the city was an affirmative action to increase the risk at that location. And so there is a conflict, so there's a disagreement between whether it was the failure to maintain under the maintenance obligation or the city's affirmative action that caused the injury. And in that kind of circumstance, I think that there could be reason to send it to the jury to have a factual determination about which of those sources of alleged negligence resulted in the injury. But we don't have that in this case. We don't have any evidence in this case that the city of Des Moines took any affirmative action to increase the risk of harm. All we have is a sidewalk with a defect that caused a trip and fall. And so we're not in that situation in this case.
Different. I mean, if I understand the district court order here, the district court says, well, Madden says that the ordinance mandatorily imposes liability. If we think that's wrong, and I think you've just said it is, because there are cases where it's not mandatory and you have a jury trial, maybe what you're saying is you'd be entitled to summary judgment if this matter were tried on these facts. But that's a different issue than kind of the statutory interpretation question of whether this ordinance makes indemnity mandatory. Do you see what I'm getting at?
I think that the statute makes the possibility of indemnity mandatory, but isn't going to require it in every situation. And I was thinking about this earlier in relation to contractual indemnity. You know, the city hires a contractor to perform a project, and one of the clauses we're going to have in that says, you know, if you cause damage, that, you know, you're acting as our agent, but if you're the one that causes damage, you're going to indemnify the city for it. And so if a situation like that arose, the city would say, well, you're responsible, you need to pay for the damages here. We could have a disagreement. Even though the contract says there will be indemnification, the contractor could say, well, maybe, but no, we think it was the city's action that caused the damages. And so there could be a factual dispute there, even in any kind of indemnification situation. And so I think the statute creates the possibility of indemnity liability in all cases, but there's the factual opportunity for adjacent property owners to say, no, we don't think that that applies in this case. We just don't have facts like that in this case.
That determination in this case, we got to the determination of the ordinance mandatorily requires it. And now what I think you're saying is no, it creates the opportunity for indemnification, and depending on the facts and circumstances of the case, you may or may not have a trial. And I understand your position here is you'd win that issue, maybe as a matter of law because the city didn't do anything affirmatively here. But that still seems like a different question than what the district court decided in this case.
I think that the district court, consistent with Madden, found that the indemnity liability exists.
Oh, sorry.
Okay. I mean, is there almost kind of like maybe a constitutional overtone of this? You know, I'm thinking, I live, you know, on Water Street. The city is constantly digging up, you know, the city owns the sidewalk in front of our apartment building. The city is constantly doing things that we don't control or have any say over. And then we can be forced to pay, compensate the city for whatever it does. And we have no control or say over that. Is there, and it's not our property, is there, sort of a, kind of a lurking, a constitutional issue where you're imposing liability on some other property owner for what you're doing with your own property. I'm not saying it's raised specifically by this case, but that's, that's maybe why the common law put the burdens in a different place than Madden did.
I want to make sure I understand kind of what we're asking here. So it sounds like the argument, if it were raised, would be that the act of imposing the maintenance obligation on the adjacent property owner is a form of uncompensated taking? Is that what you have in mind, Your Honor?
I don't have to answer questions, but I think it's only fair since it's my hypothetical. I think that's kind of what I'm driving at. It's yes, it's that the city is its own. I'm being forced to take care of somebody else's property, and it's not as a taxpayer, not as a general obligation as a taxpayer, but just and compensate for actions that I have no control over. It seems troubling. That's all.
That I think that the reason it wouldn't be a taking is that it doesn't decrease the value of your property without compensation. It's a requirement that you as a property owner, it's imposing a responsibility on you as a property owner along with all the variety of other responsibilities that property owners have. What was the other thing? I also think that if we were going to go, if that were found to be problematic, I think we would have a problem then with subsection B regarding snow and ice as well, because it's imposing the same kind of obligation with regards to snow and ice, maybe to a different degree. But if that analysis were correct, I think we'd have I think we'd again have that problem as well. I'm close to the end of my time, but Justice May, I saw you had a question.
I was just going to go back to your point about error preservation from earlier, about this question of whether error was preserved on the alternative argument about having a comparative fault determination. And just looking at your brief, it looked like you had said that Bankers Trust had preserved the error issues that it raised for review, and I didn't know if had you changed your position on that?
That I think that the argument that was raised today and in the reply brief is different than what was initially raised in the first brief. And that's why I think that the arguments that were in the initial brief were preserved, but when they went further into even if Madden were upheld, we'd still have a factual issue to give to the jury. That's what I think was new in the reply brief and not preserved. Unless there are any other questions, thank you, Your Honors.
Mr. Bryan again.
May it please court, counsel. I did briefly want to address that. Thank you for raising that, Justice May. The argument was raised at the district court about the comparative fault issue. It's in the appendix, and it, to my knowledge, was not argued at any point before this that it hadn't been raised.
District court rule on it. I see that they said that at the very last line is something like there's no obligation on the part of the city for contribution to or indemnity. Is that where you're kind of looking for as far as a ruling on that?
Because the district court just simply said they didn't have the authority to overrule Madden, and Madden holds the principle that it's a full indemnification situation. So I did want to bring up, and I should have maybe addressed this more at the beginning of my first argument. It got raised just now when Peffers was discussed. The argument we made in our brief and goes to the question that Justice Mansfield has for the city of Des Moines, and their argument was that Madden actually, from what I review, how I read it, goes against Peffers. Excuse me. After Peffers, only subsection B to 364.12 was amended, not subsection C. The principles guiding the interpretation of subsection C then were not changed, and so the Madden decision, sure.
Thank you. When was the part put into subsection C about that the city can pass an ordinance requiring maintenance by landowners. Wasn't that at the same time?
I'm not sure I understand. Are you asking if they amended subsection C at the same time they amended subsection B? I don't believe so, but I'm willing to stand corrected.
Continue with your argument then, because I was under the impression that it was, but I'll look at that closer.
Yes, our argument is dependent on, that if C wasn't amended, then going back to the stare decisis issue, what I'm trying to demonstrate here is that Madden actually sort of goes against the prior precedent. If the court was to overturn or overrule Madden, it would really just be resetting itself to the precedent that it existed. Not that the court wants to get into this back and forth, reversing itself to go back to a prior one, but I think Peffers is really the precedent that was set, and so that sort of addresses that stare decisis issue in a lot of ways.
The fact that we decided Peffers, the legislature then specifically amended the statute in light of Peffers, but they did not amend it after we decided Madden.
It's a good question. Maybe it just hadn't gotten on anybody's radar yet. I would assume this will get on somebody's radar.
It's one of the more controversial decisions of that term. And I think all 7 of us who were on the court at that time would probably agree. So I don't think it escaped people's notice. There may be reasons to take another look at it, but the fact that nobody noticed it, I would disagree.
I respect that. Okay, so that's my response to the stare decisis issue that I wanted to raise in rebuttal. And then I wanted to echo the proposition you raised, Justice McDonald, about the comparative fault issue to the city of Des Moines. They raised in their brief that there could be a situation, this just isn't it, but that's really a separate question for the district court to decide at a later date if it was remanded as to whether or not the facts of this specific case as a matter of law give rise to a claim that could go to a jury. But it is a completely separate and distinct, which differentiates then what this court's tasked with deciding, I believe, on this specific case as to whether or not the city of Des Moines ordinance creates full immunity, or excuse me, immunity, full indemnification. I note that there's a footnote in Madden, footnote 3, that talks about the issue of contribution versus indemnification, and that the city of Iowa City's claim in Madden was a claim for contribution. And I think it's interesting that the claim for contribution by the city got turned into an indemnification finding by the court in Madden, and then by footnote it says, we're sending it back because it was a motion to dismiss, and we're overturning the dismissal, and now you're back to where you were before. So then you can raise indemnification by amending your petition. I think that footnote in the Madden decision, footnote 3, is an interesting point of discussion. Thank you.
Bankers Trust versus City of Des Moines is hereby submitted. And we will have a brief pause when we get ready for the next case.